would the court inquire whether there are, to the state's knowledge, other recordings made of this interview? As the court may be aware...
I already did ask that, but I will ask it again. Are there any other recordings made of that interview?
Mr. Crump made that recording on that device. There were other people there, as Mr. West knows. ABC was present. I don't know whether they had a recording device. They can contact ABC and get whatever they want from them.
You know, I asked Mr. Crump in some of my correspondence simply to tell me whether someone else made a recording of this interview so that we could find the best possible recording.
The court has already ordered that you can take Mr. Crump's deposition. Has that been done yet?
No, not yet.
Okay, well, the best person to ask that question of, his knowledge, is Mr. Crump. And he may not know if
I've
somebody
already
has
asked him, but he's refused to answer. So I guess we'll just take the time it's going to take to schedule the deposition. But that's going to take weeks unless the court will grant us more than one deposition of Mr. Crump so that we can first sort out the issue of the recording and then go back to his other substantive knowledge of the case.
I'm not going to make a ruling on anything that has not come up yet. I would always consider motions if they're filed. Thank you. The next one is a motion to compel additional discovery. And this relates to discovery from FDLE and FBI. And it lists items numbers 1 through 10. Has the defense gone to FDLE yet?
No, Your Honor.
Okay, well, so some of these things that you've listed here are probably there or don't exist or someplace else that you can find out.
As to FDLE, I'll give you an example. The first one, number 1, we now know. We didn't know it at the last hearing when I said to you, we want everything FDLE has. And you said, well, go see. The problem with it is that if your order is to be interpreted, and I hope it will be, that FDLE will truly open every drawer in their building, then I'll probably get to it. But the reason why I brought this back before you, and the reason why I brought the FBI, which I'll talk about in a second, is we now know that though we never got it in the initial disclosures, the first 10 from the state, we now know from Mr. Wolfinger's office that Mr. Wolfinger gave a file to the FDLE which included their full investigation, and it also included the file that they received from Sanford PD, so that we now know that FDLE has 2 files, Mr. Wolfinger, and we don't have it.
Well, then go to FDLE. In my first hearing with you, I had indicated if you go to FDLE and tell them whatever you want copied, they're to copy it for you.
And I will. The frustration is, of course, when you told me that, it was about 8 days later than we got 33 more reports from the FDLE. So it's a bit frustrating to have a court order in place. I'm going to do it. I'm not saying I don't want to go down there. But now that we know very specifically certain items that the FDLE has, which we didn't know at the last hearing, I would just ask that you review the list and say...
There may be some other things that aren't even on the list.
Sure, and I'll find those out.
Well, the only way to know is to go down there, and if there's things that you think that they should have and they don't have is when I need to hear it.
Okay. Then let me ask it this way.
Okay.
FDLE definitely has Norm Wolfinger's report. I'm asking for an order from you because I consider it completely relevant and may well be Brady, but at least it's relevant that you order that they forward that to me as part of their ongoing discovery demand. Regardless of whether or not I go down and find it, they have an affirmative obligation to forward it. We know they have it. So that's one. The only other one...
I'm just trying to avoid having to come back at a later time saying, I know they had more in the file that they sent me, and I want more. So the way to avoid that is for you to go down to FDLE, look at every single thing they have in their office, and tell them what you want to copy. You make a list of what you've asked them to copy. If you don't receive it, then I would like to hear it.
Yes, ma'am.
Okay, so is there anything else to do with the motion to compel additional discovery?
As to FDLE,
Yes.
which is this one?
Well, it's going to be the same one as, so I'm going to deny your request without prejudice.
Yes, ma'am.
And that's being denied because you haven't gone down there to FDLE. So if you go down there and they don't have what you think that they should have, then you can always bring that back before the court.
Yes, ma'am.
The other you want the other demand for specific discovery is to FDLE also.
There are two, one to FBI, Your Honor, and then one to community
And it's the same thing. Does FBI have these things in a local office?
Here's what you had said at the last hearing. I had asked for you to order FBI to give me everything. You said, what does that mean, sort of? And you said, come up with a specific list of what you want, and I will consider it. That is what I've done for your consideration today. So the amended demand for specific discovery as to FBI, what I've done now is basically go through my investigation and also what I know to be their policies and procedures manual as to documents that they would have produced in such an investigation, and I'm asking for you to specifically order those.
Okay, well, we're getting ahead of ourselves on your motion
Oh,
to, no, that's fine, I just need to get to the right place. I considered your amended demand of discovery regarding the FBI and the second one regarding Department of Justice Community Relations Series is basically a demand. I didn't know that you wanted to specifically rule on it. This court's ruling would be that anything that either of those agencies has in their possession regarding this case shall be made available to the defense to inspect and copy.
Yes, ma'am. The last point, I thought I interpreted your ruling to be that you wanted some specifics. So that's why I came up
Well,
with these specifics.
you kept saying that you think they have all this stuff, and I said, I don't know what you think they have, so if you want to write down what you think they have, they may have more than you have written here. So it kind of helps it along if I say that you're entitled to inspect and copy every item they have in their possession regarding this case.
Okay. And could I, in
Yes.
my order that I'll draft for you, may I put in there including but not limited to those items identified in my amended demand for specific discovery?
Any objection from the
As a
state?
starting point?
No, in fairness to the FBI, who obviously is the federal government, I would ask that they be given an opportunity to respond to the specific thing. And they can make a demand, and then the FBI can respond and take appropriate action.
Why don't you put in your order that specifically these things, and that
Yes,
you
ma'am.
have the ability to inspect and copy, and that the FBI, if they object to any of these items, have 20 days to provide that objection to the court.
Thank you very much.
That takes care of the, that happens all the time.
Sorry.
That takes care of the amended demand for discovery regarding the FBI and regarding DOJ.
Yes, puts us back on track, I think, for the defendant's motion to compel regarding voice identification, I believe, which I just went out of
Okay?
order on a couple
I
of
have read your motion.
May I clarify one thing that relates to obtaining material from the FBI?
Yes.
Just so the court's aware. I've been in contact with one of the special agents in the Orlando office who's involved in the investigation as it relates to this case, asking for some documents and some records. And the response was that the Department of Justice Civil Rights Division has advised that all discovery requests be directed to the state attorney's office, which tells me that they won't respond to our requests, but will only respond to the state attorney's requests. So we're going to have that hoop to jump through.
Okay, well, if you put in the order that you send me that the demand will be served on those entities in addition to the state attorney's office, and then if they have any objections, they have 20 days to file the objection with the court, that may help you in that matter.
Thank you, Judge.
Okay. So now the motion to compel regarding voice identification.
Your Honor, I believe this is quite straightforward. It's really a combination of a reassertion of the obligations under 3.220, our rule of criminal procedure relating to discovery, but also a reminder as to Brady. And we have an issue in this case. Perhaps the court has heard the 911 call, which in the background one can hear an individual crying for help. There, I think, have been counted 10, 15 or more cries for help. That seems to be universally accepted that the person in the background was crying for help. And there has been an effort made in this case to identify the person making those cries for help. George Zimmerman told the first responding police officer that he cried for help and no one came. One of the other witnesses, a neighbor, observed, based upon the description, George Zimmerman crying for help. In the discovery, there have been a couple of witnesses identified who have heard the tape and have remarked that they are familiar with either George Zimmerman's voice or Trayvon Martin's voice, and in their opinion, the voice is one or the other. However, there are a number of witnesses that are familiar with Mr. Zimmerman's voice or Mr. Martin's voice that have not made any indication of whether or not they claim to identify the voice. At least there's no discovery to that effect. Yet, upon information and belief, that law enforcement has played this recording, or the recording has become known to people, and that they may have expressed an opinion. We believe that either Brady, depending on what that opinion is, or under 3.220, we're entitled to know whether law enforcement has played this recording for anyone and asked whether they can identify it, or some other person, since it's readily available on the internet, has played this recording, or that they've heard the recording and expressed an opinion. We know, for example, in the most recent round of discovery, the 9th supplemental that we got, well, backing up just a moment, on October 26th, we had some discussions about discovery, and following that discussion, on November 8th, we got some additional reports, which included some reports from the FBI. Contained within those FBI reports, although they're dated in the summer and in the spring, they note that 2 individuals claimed that they identified George Zimmerman's voice. So what I'm asking here is that the court recognize that this is potential Brady, or it is subject to disclosure under 3.220, and to direct the state to provide that information to the defense.
The court has said, at least on one occasion when we've been here, that the state knows their obligations under 3.220 for discovering Brady material. Mr. De La Ronda, I assume that you are complying with the discovery rules?
Again, we have depositions here. Witnesses are allowed to be asked whether they've heard it and then respond. I know my Brady obligations, but if the witnesses identify the voice, they can be asked. If there's no report doing that, I can't make up a report when there isn't one.
That's not correct.
It's not the state's obligation to go around and interview everybody to ask them if they heard the thing. I mean, if they know of somebody who's heard it, then they have an obligation to let you know who has heard the 911 call. But to go and interview everybody, especially since you said it's on the internet, how are they supposed to know who has listened to it on the internet and whether or not they have an opinion?
That's not the request today. The request today is very specific. First of all, to acknowledge and ask Mr. De La Ronda to acknowledge that voice identification in this case is discoverable. I
think that's already been acknowledged.
And also that if an individual who is familiar with George Zimmerman's voice expresses an opinion that it is George Zimmerman on that tape, that we should know that's clear Brady. And we have reason to believe that's already happened, and we've not received reports to that effect. If Mr. De La Ronda could speak to that, if he could simply say that there's no one that's listened to this tape by law enforcement who's expressed an opinion, that we haven't received that.
Well, you're asking him he can tell you what he has received, whether law enforcement has heard it and has an opinion. If they haven't divulged that opinion to anybody, he can't know that. But Mr. De La Ronda, go ahead and respond.
May I just clarify? I think, hopefully, if I'm not confused, Mr. West is asking for Brady material. Brady material is when a witness has been somehow listened to this recording. Number one, and let me just backtrack a second, there's been an indication here throughout that there's one voice. There actually could be 2 voices, but aside from that, If a witness has listened to a recording on their own or anything, and I become aware, and they've not identified a defendant, that would be Brady material. The fact that they've identified a defendant does not make that Brady material. That actually inculpates it. And just for an example, the defendant himself, in part of his interviews by the Sanford Police Department, was played that recording and was asked about that, and he said he didn't recognize that as being his voice. So I guess I'm technically revealing that. They've known that. I mean, it's in his interview. That's already been disclosed to them. But the defendant himself was played, part of the recording was told the recording, and he said he didn't think that was his voice or something to that effect. But they already know about that. That would be Brady material, I guess. Actually, anyway, I would argue it syncopates him. But the bottom line is, if a witness has identified his voice, they're entitled to ask that witness, and the witness will say, I did identify the voice. That's why we have deposition. This isn't like federal court where everything is listed. They're allowed to take depositions and ask witnesses about it, whether they've listened to the recording on their own or whatever, and whether they've recognized the voice.
I guess the question is, Mr. De La Ronda, and just to verify that the state has complied with Rule 3.220 and is fully aware of their obligations to do
That is
so.
correct in terms of Brady material, in terms of exculpating him. But I would argue that if it identifies him as being the voice or not being a voice, the victim being a voice, that's not Brady material.
Mr.
I guess I don't understand the request.
I'm sorry, now I'm confused at Mr. De La Ronda's position. Is the state's position that if a witness identifies the voice in the background of this tape to be Mr. Zimmerman's, that's not discoverable? Or that's not Brady?
Can I make a suggestion and tell me if this will work for all of you? Instead of having you get up and back and me hearing that, if I took like a 10-minute break, if you had a conversation about what you're talking about and then came back, maybe you'll be able to resolve it. Would that help?
Yes, we can do that. Just for clarification, though, that Mr. Zimmerman never denied that was his voice.
Okay.
He said it doesn't even sound like me. And has the court listened to the recording?
No, I haven't.
Perhaps during this recess, the court could do that. We have it available.
Okay. For purposes of this hearing, I don't think I need to hear that, but when we come back, if I do, if you tell me I do, I will. But let me take a recess, and when you all are ready, you'll let Deputy Marlowe know.
And one last point, since we're going to have an opportunity. Mr. De La Ronda has suggested there might be more than one voice on the recording. If Mr. De La Ronda has an enhanced recording, if he has a recording that's of better quality than the one that we've been provided, then we want to have that too, especially if that recording, an enhanced version, has been played by law enforcement, Mr. De La Ronda, his staff, or anyone to a prospective witness.
Okay, and that's some of the things that you could talk about when we take this brief recess. Court will be in recess, and we'll be back when I'm told you're ready. Thank you.
Mr. De La Ronda agrees that if a witness identifies Mr. Zimmerman as the person in the background screaming for help, that he will disclose that as Brady or potential Brady.
Okay, is that correct, Mr.?
That's correct.
Okay.
And Mr. De La Ronda's position is that insofar as the state witnesses that have identified the background voice as Trayvon Martin's, that Mr. De La Ronda does not believe he has any duty to disclose that fact or that opinion, but that would rely on us to discover that through the deposition
Okay.
phase.
Mr. De La Ronda, do you agree that the state has an obligation to let the defense know who has in fact heard or has disclosed to the state that they have heard the 911 call?
I don't know if the state is, I've listed the witnesses, all of them that have potentially listened to the recording, yes, Your Honor. And they have the opportunity to depose them, so I have no objection. Obviously, they're entitled to that.
Right.
I guess if the court's question is, do I have to tell them specifically who has been played or who has listened to? Some of them may have done it on their own, In other words, through YouTube or something.
No, I'm talking about the ones that the state has either, the people have said to the state, I've listened to the 911 call, or the state has played the 911 call to the person. Those people have been disclosed?
No.
Yes, on discovery, they have been disclosed as witnesses, yes, Your Honor.
They've been, they've been disclosed in that Mr. Deliranda says they are somewhere on the witness list. That they've listened to the recording and made an identification is not anywhere indicated specifically in discovery except for a couple of witnesses. Mr. Deliranda knows there are other witnesses that have been disclosed that have made an identification, but he won't tell us which ones those are.
Okay,
Your Honor, I guess
that response.
my response is, in the state of Florida, whether we like it or not, there is very broad discovery. That's why depositions are taken. Sometimes witnesses are taken for 3 hours. We've already had a witness taken for 3 hours that I thought would take 15 minutes. So they can depose witnesses and they can ask them, have you listened to the recording on your own or at any time? And what was did you identify the voice as being the victim's voice?
I don't think in the response to discovery that the state provides in the cases that I'm familiar with that they're required to identify exactly what each witness would or would not be able to testify to. They have Category A, Category B, and Category C witnesses. They are to disclose whether or not the defendant has made any type of statement, if it's in writing or if it's in recording, and where the defense can get a copy of or come to listen to. I don't think that there's any greater obligation than is set forth in 3.220. And if the state says that they're complying with it, then this court, as an officer of the court, will have to take them for their word. So if they've listed Category A witnesses, you're free to go ahead and take their depositions and make a determination as to what they do or do not know.
The last category that we really didn't talk about yet that we should identify, and that is those situations where a witness has been played the recording that might be familiar with Mr. Martin's voice or Mr. Zimmerman's voice, and that's why they were played the recording, and that they did not make an identification. We believe that that's discoverable, especially insofar as whether they would be familiar with Mr. Martin's voice, listen to the recording, and could not identify the voice as his. We think that's also Brady.
Or I'll tell you what, in that particular context, I will, if I'm aware of something, I will list it, but they can do a discovery, but I'll take the higher road and I will list those specifically if they have been unable to identify a voice.
Okay, thank you. Does that put this issue to rest?
For today, yes,
Okay, thank you very much. Then we're on to the defendant's motion to modify conditions of release.
Yes, good morning, Your Honor.
Good morning.
Did you?
I have read the motion. I do not have to have you reiterate everything that's in the motion. Just an argument would be fine.
Fairly standard. To the extent that you would like, I do have Adam Bissant, who is available. He is the community control officer, who is GPS monitoring officer. So a couple minutes of testimony for him just to document Mr. Zimmerman's compliance.
Sure. If you'll please come up here to the
I
podium.
believe he's outside in the witness room, if I can have about 30
Yes.
seconds.
Swear or affirm that testimony says that will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may proceed.
Good morning, sir. State your name
Good morning, sir. Adam Vincent.
and your occupation.
I'm a senior probation officer.
And what are your duties within that?
Wide-reaching, but generally I supervise clients that are placed on GPS monitoring by the court system in Seminole County.
And would that include George Zimmerman?
Yes, sir.
And how long have you supervised him?
I believe since his first release, I think it was April 22nd or 23rd.
And then there was a period of time when he was put back in jail for a short period of time and then re-released on bond, correct?
Correct, sir.
Specific to that time that he was re-released on bond, I believe, starting July 5th, if you could advise the court how he has or if he's failed to comply with any of the conditions you placed on him.
No, sir, we've had no compliance issues with Mr. Zimmerman. Since he's been re-released, we've not had one problem with him.
Okay. Any problems with him doing whatever it is you asked him to do?
No, sir.
Any concerns with his willingness to, for example, appear in court, to comply with your conditions, and to live within the confines of the GPS monitoring?
No, sir, he's demonstrated complete compliance in regards to GPS monitoring.
Nothing further on.
Very briefly, Your Honor. Vincent, I believe, did you testify last time in court?
Yes, sir.
How long ago was it you testified? Approximately.
I would say about 4 months ago, sir.
And it was on this same issue, correct?
Yes, sir.
Okay, so nothing has changed from the last time you testified, I gather?
Yes, sir.
Thank you very much, sir.
Okay, thank you. Any redirect?
Just briefly, of course, you were testifying at that point to allow him to be released after he was reincarcerated, correct?
Yes, sir, that was correct.
So the difference being that he's now been on your supervision and control for how many months? Since July?
Well, give or take minus the time he was in custody, so, we're talking seven months minus the time served time.
And then particularly since your last testimony, that would have been the compliance he's shown to you since July, correct?
If that was the date he was re-released, I don't know offhand, but I believe it was approximately that date. Yes, sir.
Thank you. Nothing further, Your Honor.
Okay, thank you.
No.
May Mr. Vincent be excused?
Yes, Your Honor.
Thank you, sir, you are
Thank you, Your Honor.
excused. Do you have any other witnesses that you wanted to call?
No, Your Honor.
Okay, State have any witnesses?
No, Your Honor.
All right, let me hear your argument.
Again, Your Honor, the motion outlines the basis for it. Mr. Zimmerman has been compliant with his conditions of GPS, as often argued by the state as a basis to simply keep him on because he's doing okay on it. Particularly, you might recall from a review of the motion that Judge Lester had placed him back on GPS. I think that he has shown himself where he should be allowed to be free and not be on GPS. That's one request. More importantly, Judge Lester, I think in response to some frustrations that Judge Lester acknowledged in a very specific motion or order granting bail, that Judge Lester limited my client to Seminole County and Seminole County alone. That restriction has been particularly frustrating for a number of reasons for the defense and for Mr. Zimmerman. Firstly, this is a high-profile case. Mrs. Zimmerman is living in hiding. You are aware of all that. I'm not going to belabor the point. But because of that and his need to live truly in disguise and in hiding, the fact that he's also limited within Seminole County makes that process much more difficult and therefore much more dangerous. Two, we had asked at the last hearing that the court consider simply allowing him to have a greater geographical limit. The Judge Lester at that point, again, I think evidencing his frustration with Mrs. Zimmerman, said, I'll let him go to Orange County, but only to go to your office. That has also been very problematic for the defense and for Mrs. Zimmerman because it is very difficult to accomplish him meeting with expert witnesses, meeting with our investigators, and just helping us get ready for the case. Beyond that, quite honestly, I don't know why somebody who is, if you were to leave him on GPS, which I don't think we need to, but is on $1 million bond, has always evidenced a willingness to cooperate. He was, of course, out of state when FDLE asked him to come back into state to surrender himself, and he did. We know, and you know from now review some of the discovery we presented, that he completely cooperated with law enforcement before his arrest. The very issue of his innocence is an issue for you to consider in not only determining to release him, but also, as per 903, the statute dealing with bond conditions, you should be considering the issue of his innocence as an element for how to set a condition of bond. Why a man who has been accused of committing an act that now the evidence seems to support was done solely in self-defense should be under any restrictions, should even be prosecuted is another issue, but be under any conditions aside from generally stay within the confines of the state of Florida, doesn't seem to be any basis for. So I'm asking you to consider simply removing him from GPS, allowing him to stay free at liberty, within the state of Florida, as he should, unless you get prior approval for out-of-state movement. And if you don't consider that, to at least remove the geographical restriction so that he can travel as he should be able to as only a citizen accused, not a citizen convicted. And there's nothing in his history, nothing in his actions since his initial release and his second release that would suggest that these type of restrictions are necessary. So I'm just simply asking that you review it and modify it.
Thank you very much. Response?
Please support, and I apologize, since the time frame, I wasn't able to do a formal reply, so if I may just take a few minutes to do an oral argument to the court. First of all, we object strenuously to any modification of his GPS or his boundaries in terms of Seminole County. This defendant should not take advantage of what happened, or the court should not allow him to take advantage of what happened. That is, he lied to the court, former judge, regarding his ability to raise bond, and he also had, let's not forget, a second passport in terms of his ability to have flight. Now, only after we found out and after it was brought to the attention did he then come forward regarding admitting having a second passport, that, by the way, at some point was being hidden in a safety deposit box by his wife. So I guess the defense wants the court to just summarily forget about all that happened and say he's been a wonderful person because we have this sheriff's officer or deputy who says he's complied with requirements. So that is my first position in terms of the argument that we strenuously object to any modifications to condition of release. Now, the second point, I guess, is why? Why do they now feel, because this, I believe, is the third or fourth time that we've gone over this matter about bond. Originally, it was set at $150,000. We had a bond hearing. Court said it. And then there was further argument regarding something that the court was not aware, that is, that Judge Lester was not aware had occurred in front of the court. That is, the defendant and his wife, particularly his wife, lied to the court about something. That was serious enough that I filed a motion to revoke his bond, and the court agreed and locked him up for a period of time. Then the court, after analyzing everything, made a determination that an appropriate bond would be $1 million, and also made further restrictions. Did not allow the defendant to go and wander through anywhere he wanted to, but restricted the defendant not just to the state of Florida, but more specifically to Seminole County. That is, the court was concerned about this defendant in terms of his credibility, in terms of showing himself, etc. So our position is that he should be restricted to Seminole County, and was our position at that time. Then what happened is they filed a motion to in some way modify that, to allow him to travel to Orange County or possibly move to Orange County. In my recollection, and I think there's a transcript to that effect, the court, Judge Lester said, I will allow you to travel to Orange County to visit with your attorneys, but you have to tell ahead of time where you're going, how long you're going to be there. This isn't just you just wandering throughout wherever you want. And we would ask the court to follow that same requirement. That is, now the point is the defense keeps saying, we need this because it's not safe. It's not safe? And the defendant's got to be in disguise? My recollection is this defendant appeared on national TV. He put his profile right up there for everybody in the world to see him. And now he's arguing it's not safe? This defendant, the last time I think we were in court, or the time prior to that, came in through the front. And the media was following him. But there's so many threats against him and he's so scared. You can't have it both ways. You can't have it where you want all this publicity, where you keep bringing up the publicity, you keep bringing up the case, that is, the defense does, and then argue that it's unsafe for him there. Who's generating all this publicity? Why are we here really for this motion? Is it more for publicity? Maybe it's for autographs. Maybe now the defendant wants to get more autographs. Maybe he wants to travel to West Florida, so he's got some people who can pay him more money, or pay him money to get his autograph. Is that what this is about? I would argue that an objective person reading this would come to that conclusion. That what it is intended here to do is to, again, relitigate this issue, to bring it to a forefront, to get potential jurors biased against the state. Because throughout this motion, there's language that I respectfully disagree with in terms of the evidence. There's already been a finding by a court, not just one court, two judges who have made a determination there was probable cause here for the charges. But the defense keeps bringing up, well, we've got additional evidence, we've got additional evidence. I respectfully disagree as to the conclusions read or stated in the motion by defense. They refer to a particular witness, and I think they refer to witness number 6, for instance, on page 4 of their motion. What they neglect to inform the court of, that same witness number 6 also gave a sworn statement to me, and we had the same issue in front of Judge Lester, when in the prior motion they only put part of the thing, and I said, hold on, let's get a complete record in front of the judge where that witness described what occurred. And it wasn't exactly what's been represented here. This is true in one of the first interviews, but then this witness further clarified whether there was actually hitting, and he described it as not like blows. And so that's just a minor point that the defense tries to, I guess what they're trying to do is just get publicity here or get this up in front of Your Honor, and in a way, maybe it's for the civil lawsuit that's pending now. I don't know. I don't know what the motivation is, but let's take it at heart as what they're saying. They're saying that there is some threat out there, or it's going to be advantageous for him to be able to confer with experts. They haven't said, Judge, we need expert A to meet with him at this time. I think the court could say, limit it, just you can go visit this expert right here in Orange County and come back. They haven't asked for that. They just say, well, we want to be able to wander throughout the state. I mean, when I say we, meaning the defendant wants to be able to wander throughout the state. Again, I go back to, is it autographs? Why are we rehashing this issue again? Why is there a need to rehash the facts? There's a statement on page 4 about sustain at least a broken nose, or broken and bloodied nose. What evidence, what witness has said that he has a broken nose? My recollection is the witness said he may have a broken nose. There wasn't x-rays taken of this defendant when he went to the doctor. The doctor's report was submitted in evidence. That's all been reviewed by the prior court. The fact there was or was not a civil rights violation, that's irrelevant. There's on page number 5 under D, statement made, asserted here that there's no evidence that he acted in racist ways. I've never alleged on behalf of the state of Florida that he killed the victim in this case because he hated African Americans or black. Now, if the record is complete, as the court should be made aware of, there was a witness, I believe it was witness number 9, who said he had made derogatory comments about black individuals. There's also the defendant's own Facebook, where he makes derogatory comments about Mexicans. One could argue that those are racist views, or those are racist comments. But my point is not to regurgitate this in front of the court again, but to have a complete record. Why are we here? Why is all this being thrown out here? Why is there mention about this CVSA test if it's not admissible in court? Why are we rehashing that if the defense knows that it's not admissible in court? The fact that he passed a voice stress test. Why is this mentioned again in the motion? There's also mention about that it didn't go to the grand jury here in the 18th Circuit on page number 7. Well, if you have a complete record of that, comments about that in terms of the context, one of the witnesses in this case, Captain O'Connor, was asked about that, or made a comment about that in his deposition. And he stated that, and defense can correct me if I'm wrong, he stated that he actually heard from the prosecutor here at the 18th Circuit, who stated he did not want it to go to not Mr. Wolfinger, but one of the assistant state attorneys, who said he did not want it to go to the grand jury because he was concerned that the grand jury would indict him, and then he would have to try the case. And apparently that had occurred in the prior case in which the jury did indict somebody who had killed, I believe, black individuals. I can't remember if it was 1 or 2 victims, and he didn't like that had happened because it ended up going to trial and the person was found not guilty. So if we're going to have a complete rehashing of all the facts here, I first of all I don't think we need to do that. I think the court needs to concern about what has changed from what had occurred before in terms of the court's findings. And when I say the court, I respectfully mean also the prior judge. But isn't the defendant safer if law enforcement knows exactly where he is in terms of his GPS and in terms of his actual location than him wandering throughout the state of Florida? Isn't that more beneficial to the defendant? Because if there's an actual threat, then they really can't respond to it. But again, If there are all these threats out there, that's why we need to change this, why is he appearing and walking in through that front door and making the media follow him through? Why is he appearing on national TV? Why is he agreeing to give autographs in return for money, or however that was portrayed in the media or in the own website? Again, so the court, to have a complete record of this, needs to remember that there was a passport. He had a second passport, and that's why the bond is such. And that's why the court previously made a determination that he is to be in Seminole County only. What evidence is this of these threats or all these security issues? So what it boils down to, it's going to be beneficial for the defendant to wander throughout the state, and perhaps it's a money thing. Maybe there's a need to get more money for his benefit. I don't know, but not to belabor the point, I respectfully disagree with what's been alleged in the motion. I didn't have time to respond, and so I thank the court for allowing me to take a little bit of time to respond. But one final thing, there's been, I think in the motion, there's attached a deposition or parts of a deposition of investigator Detective Santiago about this meeting where members of the Sanford Police Department met and discussed the case, and that there was discussion about whether to charge or not, etc. Well, Detective Serino hasn't been deposed yet. He was the lead detective. He's the one that made a determination that to submit it to the state attorney's office in terms of manslaughter. Now, recently, it was brought to my attention, in fact, just last week, by Mr. Jose Baez, who represents Mr. Serino, that he submitted to me what he felt was Brady material. And when I got it, I knew I was coming to court, so I provided that today to the defense. And what it is, and I haven't finished reading it, all of it, but it's apparently prior drafts of the final report or supplemental report by Investigator Serino. And so there may be inconsistency or stuff, but in just quickly reviewing it, I note, and defense I've given a copy of, that at least in the first two drafts, and this is, I think, emails going back from Captain O'Connor to Chris Serino and Randy Smith, that in the first two drafts, Detective Serino wrote the following: based on the above investigating findings, your fine request charges under 782.042, to wit, murder in the second degree, to be filed against George Michael Zimmerman. This case is being forwarded to the Office of the State Attorney as a request for capias. Then in the second draft, he does the same. In the final one, he does say manslaughter. How that came about, they can depose him and find out. My point in saying that is not to talk about, okay, second degree or manslaughter. That's where we have a trial. That's where we have a hearings in front of the court. But for the defense here in their motion to keep insinuating that he shouldn't have been charged with second degree, that there was something improper done by the state attorney's office in the Fourth Judicial Circuit, I respectfully disagree. But that's what, it doesn't matter what I think or what the defense thinks. It's what a jury will think. It's what the court will think. Aren't we here to do that? And let's get right down to the heart of the matter. There's no dispute that this defendant shot an unarmed 17-year-old young man. There is no dispute that this defendant followed that young man. He could have stayed in the car when the police told him don't follow him, but he didn't. What occurred there, it will come out of the trial, or at a hearing, and or both, in front of this court. But let's get to that heart. Let's try this case in the courtroom, and not to the public. Because if we're ever going to try this case, we need a jury to be unbiased. And so I respectfully, in conclusion, disagree and object to the motion to modify the conditions of release, and I appreciate the court allowing me an opportunity, since I didn't have an opportunity to respond in writing, to do so such in oral. Thank you.
Thank you. Mr. O'Mara?
If I might, thank you, Your Honor. Staying on point to the motion itself, there are threats out there, and if you want, we could present them. The suggestion that this case is not one which has inflamed the passions of both the nation, the state, and Seminole County is absurd. It has. Unfortunately, it has, and it shouldn't have. And not for today's purposes, as Mr. Delaronda said several times. But the reality is that the way this case was handled in the beginning turned it into a fireball of frustration for the entire nation. And we'll deal with it. I'd love to deal with it in a better way than we're dealing with it already, but we'll deal with it. My concern is that my client has to deal with it in a way that he shouldn't have to. He shouldn't have to be in hiding. If nothing else, if the state is completely correct in their position that this was a tragic event that led to the death of a 17-year-old, and who knows, they could argue it may have been able to be avoided. So be it. But does that turn him, somebody with, look at Exhibit B, with the picture of his face, the way it was pummeled, with a broken nose, a smashed face, blood dripping into his lip. Is that what they're saying, that under Exhibit B, that we should just ignore this? He yells to you that it should be tried in a courtroom, and I agree, but I want to be ready for that. So I'm a little bit frustrated because prior judge who reviewed this and determined his bond conditions never got a chance to see that picture. See, because I didn't get a chance to see that picture until a month ago. So I really want to try it in a courtroom. I just want to be ready to try it. But what I don't want to happen is for my client not to make it to that courtroom because of all of the animosity that has been inherent in this case and the way it's been handled by everybody, the media, family's handlers, those who seem to gain benefit out of having it sort of the incendiary nature of it, but he's really the victim of it. And that's all I'm really trying to protect. He's my client. And if in fact you consider the facts that I think you should consider in addressing conditions of bond, I think you should look at the evidence that we can present. Now, are we having a mini trial? No. But one of the elements you ought to consider on a condition of bond is whether or not the level, the weight of the evidence against him. And the reality is, the more we find out about this case, the more you're made aware of it, from things like the statements that you reviewed that he gave, pictures that we now know are out there, statements from law enforcement that tell us there seems to be a consensus that he shouldn't have been charged. We find out witnesses who support the contention that Tracy Martin said it wasn't his son's voice. I know it sounds like it would just, let's all just throw it at the judge. It's just confused from both sides. But the reality is we have a right under 903 to talk to you about the weight of the evidence, or in this case, a lack of weight of the evidence in determining a bond condition. So, staying on that point and focusing quickly, we can't forget that it was only a couple of weeks after all of this that a Sanford Police Department car was shot up. So there are animosities out there, both against the police department, and you can't read a paper without knowing that some of those animosities are against my client. That's why he's in fear. The idea that he wants to live a life of publicity, wish he could, actually, but he wouldn't be wearing a bulletproof vest if that was an issue. He does not need to be limited to Seminole County, and there's no reason to continue to do that. We could present evidence as to why Seminole State College told him, you can't come back. As to why his employer said, you can't come back. As to why a nursing school told his wife, you can't come back. His employer said, look, if you need anything, pick a place, we'll meet you. Don't even come to pick up your stuff. He doesn't need to live under the constraints that a previous court placed him under because of frustrations of thinking that he was put upon by my client not being honest. Let's not forget, my client didn't even testify at the hearing that so frustrated Judge Lester. It was the fact that his wife didn't acknowledge that they had about $130,000 in a legal defense fund that they didn't know what it was going to be used for. And could she have been more honest? That's for another person, another judge. Quite honestly, actually it is you maybe. Has nothing to do with my client. Question is reasonable conditions of bond and the burden, the financial burden that he's under. He does not need to be on GPS because he has evidenced his willingness from day one to present himself to the court when he's supposed to and how he's supposed to. And he does not need to be limited to Seminole County because there's no reason to do so. This is not a person who in most cases you would say, you've missed some court appearances, you failed to appear court, you have aliases, you have a prior criminal record, you have reasons why I need to add additional restrictions to you. In Seminole County, your criminal activity was occurring by you traveling around the state, so I can't allow that to happen. There's none of that here. All we have is a person who seems to have been accused for having to protect himself from being attacked and battered by a young 17-year-old child, which is the mantra that keeps coming out. But that mantra seems to ignore the fact that that young 17-year-old child at 6'2", 160 or 70 pounds was able to accomplish doing this to my client before he got himself shot. That's what I think you ought to consider in determining whether or not a citizen accused should be held under any greater restraints. The $1 million bond will keep him here. He wants to be here. He's looking forward to an immunity hearing before you in a trial so he can actually get the evidence out that you know we're frustrated for not getting. So let's get to it, but give him the liberty that he deserves to travel throughout the state of Florida like he would with any other criminal defendant. Usually, how often can I get before you, can any criminal defense attorney get before you and argue and argue and argue undeniable evidence of innocence? Just consider it and determine to let him go out through the state of Florida and to remove the GPS. That's all.
Thank you. No further argument. The court has considered the motion to modify conditions of release. I have read the motion and the exhibits and heard the argument of counsel. The motion is denied. The next motion is a motion for clarification of order setting bond. I'm a little confused about that because you're asking me to clarify something that another judge has done when I have not spoken to him. I don't know what was in his mind when he set his bond order. That is the bond order that's still in effect. You wanted me to clarify specifically, I guess, his ability to talk to witnesses.
Yeah, and I'm being overly cautious on this one, to be honest with you. Here's what happened. In the initial bond order.
Okay. I have I believe the second order here. The initial bond order,
I can tell it to you.
Okay.
It's one sentence. In the initial bond order, it says the defendant has had no contact with any witnesses. And because of that, and because of my client's sincere concern in complying with court orders and being very, very careful, he has limited himself from contact with people that I don't believe Judge Lester included or intended to include in that category. Now, if you go forward to the one that you do have in front of you, it sort of says, have no contact with, I think it says victims' family members.
victim's family directly or indirectly,
Yes.
except as necessary to conduct pretrial discovery through his attorneys.
And if that is the witness restriction, I'm very okay. What I didn't want to happen is for him to contact witness Joe, who's a witness, nothing to do with the family, and then for someone to complain and for us to come back before you on a bond violation because in the first order it sort of said no witnesses, in the second one, I just want to be clear, I talked to Mr. Delarianda about that. We could not come up with a good solution to it, which is why the motion's been filed and why I ask you, I guess, to just say the condition of the second bond order that says no contact with the victim's family, indirectly or directly, stands.
Judge Lester in his July 5th, 2012 order lists A through J of things the defendant can and cannot do, and none of them say that he cannot have any contact with other witnesses. It just restricts the contact as indicated in paragraph B with the victim's family directly or indirectly. So your motion for clarification of order setting bail will be denied because I can't clarify what Judge Lester was thinking and it's done. I'm very literal and I'm going exactly what it says. It does not restrict any other contact.
Yes, Your Honor.
Okay.
Thank you for
Does that help?
It does.
So then I guess we need to look at what possible future hearing dates, in case you have any further motions. I have a couple of dates that I could offer to you. Whether you need them or not, I will set them aside. January 8th all day, February 5th all day, March 5th all day.
We take them all.
I'm available February 5th or March, January 8th, I think is the court. I have a 3851 evidentiary hearing that day that starts actually on the 7th.
On which day?
It starts on January 7th.
And how long
continues.
is that one?
Right now, we schedule it for 3 days, Your Honor. As the court knows, that's, defense kind of controls that, and I'm just, so they've scheduled, I don't know that it's going to take 3 days. I hope not, but.
Well, here's what I'm going to do. I will set aside January 8th and January 5th all day. If you're going to use them, fine, let me know. And if you're not going to use them, we'll release them.
January 8th and February 5th?
January, did I say it the other way around? January 8th and February 5th.
And then you also mentioned March 5th.
I will keep that opened also.
Great.
So if you'll let me know. And they would be in this courtroom. I've checked with Judge Rex Siedler, and those are days that she has arraignments, so she will not be using this courtroom anyway.
Great.
Would that be at 9 o'clock, Your Honor?
9 o'clock or 1:30, whatever time that you all agree to. I'm just keeping the days open, and you'll let me know.
9 o'clock is fine with the state. May we, and I think both sides, may we just, and we briefly talked about it doing in terms of, I guess, clarifying in terms of responding to the court within 48 hours, if both sides can agree that motions would be filed 96 hours ahead of time, and then I think we can come up with something where the court would be able to get from both sides replies and everything, and I think both sides can agree to that.
We'll come up with a gentleman's agreement that if we're going to we need to get everything to you 48 hours ahead of time. So we need to acknowledge that we
Getting
need
the
to
stuff
back
I
it up.
got on Friday was
Right.
perfect, because I spent Friday afternoon looking at all of it and was prepared for this hearing, and was able to do my regular docket on Monday. So whatever you can come up with, Sarah, these needed to be filed in the court file.
Thank you very much, Your Honor.
Okay.
Thanks for the time again, Your Honor.
Okay,
Appreciate it.
thank you very much. Court is in recess.
You want to address the docket sounding tomorrow?
Oh, right, docket sounding tomorrow, so we'll just continue the docket sounding to my docket for January 8th.
Thank you, Your Honor.
Okay, so you're excused from tomorrow.